Ms. Glinka.
Good morning, Madam Justice and Justices of the Supreme Judicial Court. My name is Charlotte Glinka. I represent the Joslyns in this matter, the appellants. We are not asking this Court to rewrite the law or create a common law exception to Chapter 260, Section 4. We are not asking the Court to undo the legislative intent and purpose behind that statute. And we are not asking the Court to do anything that would create or instigate or promote more litigation. Instead, we are asking this Court to follow the plain language and plain reading of Chapter 260, Sections 4 and Section 12, which would, in a case of fraudulent concealment, toll the time period within which a claim for medical malpractice may be brought.
I take it you limit it to fraudulent concealment, not just accidental concealment or negligent concealment.
This is concealment by a physician who is under a fiduciary obligation and duty to disclose certain information to a patient.
That sounds like negligent failure to disclose to me.
This is concerning a situation, in this case in particular, where a doctor knows the circumstances as to what really occurred during the surgery and fails to disclose that information to the patient.
What's the evidence of fraud as opposed to negligence?
And there isn't a requirement in a fiduciary setting that there be actual fraud. The cases have held that a doctor who is in a fiduciary relationship with a patient has an affirmative obligation to disclose material information about the circumstances of that medical event that put that plaintiff and put that patient on notice as to what occurred.
I understand that, but as I say, usually the breach of such an obligation is negligence, not fraud.
But under the case law, Your Honor, fraudulent concealment in the setting of a physician is the failure to disclose. It is not a fraudulent per se concealment. It is a concealment, an actual intentional concealment of certain information that the plaintiff should know.
I take this as the first case where we've been asked to construe the relationship between the fraudulent concealment statute and the statute of repose.
That's correct, Your Honor.
Have any other states done it?
There are a number of states, which I have cited
in
my brief, that have created an exception to the statute of repose in cases precisely like this one, where there has been a concealment of material facts concerning a medical event which has been kept from a patient, such that the patient is then not on a fair footing to begin the inquiry as to whether something may have gone wrong, something may have been negligently done.
But our legislature didn't provide that exception in the statute.
Well, I'm suggesting, Your Honor, that the two sections of this statute have to be read together. Section 12, which says that the time prior to the discovery of the concealed information shall be excluded in determining the time from within which that action may be commenced.
You may not want to answer my question, but it says fraudulently conceals.
I would suggest, Your Honor, if in this situation and on these facts, if this young baby was having surgery and the doctor, as in this case, tells the parents, your baby died, we're sorry, but doesn't tell the parents the most crucial piece of information.
The parents could ask. The parents, in fact, did ask for the file, did they not?
They did ask for the file.
And they were not given the file.
They were denied that file.
They were denied it or they were not given it?
They were denied. They called after they...
Did they commence an action because they were entitled to file? In other words, there may be that they had an action for being denied access to information, assuming that, I haven't looked at the statutes, but generally speaking, you have access to your own medical record. I mean, that may go to the fraudulent concealment, but that's a different...
But the issue is the reason the parents were asking for the records was not because they suspected or should have suspected that there may have been some negligence that they should investigate, because what they were told and what they were given in writing on the death certificate was something markedly different than what had occurred.
Is there any evidence in the record that indicates that the reason they were not given the file in their case after they requested it was a reason that was different than that given to other people who had requested their own medical records?
The affidavit of Mrs. Joslyn indicates that she phoned the nurse that she had dealt with at the hospital and asked if they could have the records because there was an issue about their other children possibly having the same metabolic disorder, and was told, as is set out in the affidavit by the nurse, that contains a lot of medical jargon that parents don't understand, so we don't send the records.
Yeah, but is that in fact the policy of the hospital? Do we know?
Not as far as I know, Your Honor. The policy of the hospital...
So we don't know whether the reason that was given to the parents in this case was a fraudulent reason or it was the standard reason?
Or just one nurse trying to deal with somebody saying, you're really not going to understand it.
Well, the defendants would suggest that there needs to be a written request for the records, and that's why the records weren't sent. But that's not set out anywhere in the record, that there is a need that there be a written request for records. But going back to the issue of the parents' knowledge, though, and what the reason was that they thought their baby died is not, in fact, what was the truth, which is that the baby's heart was lacerated and the baby bled to death. Now, that was not provided to the patient's parents in the record they did receive, which was the death certificate. The death certificate says nothing about that.
And that was filled out by at least the information provided by the doctor?
Yes.
Now, if we accept the best-case scenario for you, that the doctor knew he had done a terrible act of malpractice, that he intentionally decided to cover it up by not releasing medical records, by perhaps putting other things in medical records, by giving, well, best case for you, false information for the death certificate. So the suit should not have been dismissed. That would be point one. But point two would be then what? These issues of whether he did all these things, including the fraud, would be tried to a jury as issues of fact?
Absolutely, Your Honor.
And plus the issue of the statute of repose?
Well,
And then they'd have to make the decision of, was there fraud here? If there wasn't fraud, then the repose statute knocks it out and we fine for the defendant? How does this work?
I'm suggesting, Your Honor, that under Section 12, the fraudulent concealment statute, that the repose period does not apply in this case because of the concealment on the part of the doctors.
But that would be a fact, as Justice Graney suggested, that would have to be found by the jury. Because
Whether there
12
was-
wouldn't apply until you find fraud.
to begin with.
They'd have to find that there was concealment, an act of concealment.
Fraudulent
No.
concealment.
Fraudulent concealment.
Ms. Glenke, let me just ask, we're here on summary judgment, correct?
Yes.
Did you submit any evidence by any expert that there was false information on the birth certificate, on the death certificate?
I believe in the
Not incomplete, false.
there is not false information on the
Okay.
death certificate,
But
but there
you-
is not accurate and truthful information on the death certificate as to the cause of death. The underlying conditions that this baby had are listed on the death certificate, but what is not listed, and most significantly not listed, is what caused this baby's death. And that was the laceration of the ventricle and the baby's massive blood
There
loss.
is, as I recall, there is a box on the death certificate that says cause of death, correct?
Right.
And do you have any expert that said whatever was placed there, now you've got an expert who's looking at all the records, that is a false cause of death?
The actual cause of death, the expert letter says, Dr. Cherish's letter, which is was contained in the offer of proof and is contained in the brief, says that the cause of death, and this is supported by what was contained in the autopsy, was the laceration of the heart, the ventricle of the heart, and the massive blood loss. So by logical extension, that information is not contained in the death certificate, which is required.
But is there any indication anywhere in the record that the death certificate had been, quote, doctored up?
It's not an issue of doctoring the records, because the causes that are listed on the death certificate are, in fact, conditions the baby had
It
in the
has to
days
be
and weeks preceding
Ms.
this
Glenke,
event.
I know you don't like the word fraud in the statute. It's not concealment. It's fraudulent concealment. And you're here on summary judgment. And I'm simply trying to explore what did you put in the record that would raise an issue of fact that this concealment was in fact fraudulent.
What is in the record is the affidavits from the parents who spoke with Dr. Chang both before and after the surgery. There is no indication in the record that they were, first of all, advised of any risks or complications.
Let us stipulate that there was concealment, right? There was concealment, but the statute, to get out from behind, it doesn't say if a person liable to a personal action conceals the cause of such action. That's not what the statute says.
Right.
And I'm asking you, on a motion for summary judgment, what's the evidence that you say gives rise to a disputed issue of fact that this concealment, I'll accept the parents, that it was concealed. You've put that at issue. I will accept that there was a cause of death and somebody says the cause of death should have been something else. What's the evidence of fraudulent concealment?
The evidence is contained within the fiduciary responsibility of a doctor to tell the patient the truth as to what occurs.
But where in the record does it indicate, what's your best case, just humor us for a minute, what's your best case that this was done deliberately?
I can speculate as to the motives of these doctors, all of whom were starting out.
But where in the record? Can you point to something in the record that suggests that they did it deliberately?
Could you get another expert doctor to come in and say, no, nobody engaged in this would have failed to have told, or...
Well, Dr. Cherish's letter sets out that the parents should have been informed about what took place in the surgery. That's a minimum requirement, that a physician tell the patient about any untoward event or anything that occurs in the surgery that is something that was not expected to occur. And that didn't take place here.
Did you depose Dr. Chang?
No, there was no discovery in the case, Your Honor, prior to the motion for summary judgment. We submitted affidavits of the plaintiffs.
This may be beyond the record, but doesn't the hospital also have some duty and responsibility to inform patients or their families if there's some untoward event?
They do, Your Honor, and Children's Hospital is also a defendant in this case for that reason.
But
there
they
is a
have the
responsibility.
charitable cap, don't they?
They do.
Yeah. Did you ask to depose Dr. Chang before this motion was heard?
At the time that Dr. Chang was served with process, there was a deposition notice to him.
But it
And
went
the
ahead
motion
without the deposition taking place?
That did not take place prior to the motion to dismiss being filed.
Did you ask to take his deposition before there was a hearing on the motion to dismiss?
Other than giving the deposition notice, no. That was postponed during the course of these events.
So there was an agreement by counsel not to take the deposition?
Yes.
Which might have gone a long way to proving fraud or not proving fraud. But
But
you think
again-
you have enough anyway?
Yes, Your Honor, it may have, but again, it's a jury issue. It's for the jury to decide whether
Well,
that...
it could be, if assuming your legal position is correct on the interplay between the statutes, that you have enough to survive summary judgment on the fraudulent aspect of the concealment. Because, your burden on summary judgment is, it's been described as a toe hole, any possible inference, those kinds of things, and that gets you pretty far.
Correct, and I think that Judge Connolly was constrained by what he felt the statute of repose required, which was to not allow this case.
Yeah, no.
But
We're
certainly he cites...
concentrating on the bigger issue of whether, the statute of the fraudulent concealment plays any part of it in the repose scenario.
But certainly he cites Judge Hillman's similar holding in the case that dealt with the North Middlesex case, which dealt with the issue of the statute of repose, and where Judge Hillman said that in the event there is a concealment, a fraudulent concealment of material facts, that should, for public policy reasons, not allow the statute of repose to cut off the rights of the individual. And we're suggesting that that same principle should be applied here.
Ms. Glinka, can you point me to a case where a failure to carry out a fiduciary obligation to disclose information has been determined to be flawed as opposed to the equitable doctrines of forfeiture by wrongdoing and the other causes of action that you mentioned?
Well, there are a number of cases which I cite in my brief, including a case from the Nebraska Supreme Court called Mueller versus Thout, in which the court applied a doctrine of equitable estoppel to preclude a repose period where the plaintiffs relied on a doctor's misrepresentations about the cause of the baby's death in order to file suit.
Yeah, no, I understand the other doctrines, equitable estoppel, I mean, a variety of other. I'm asking you whether in a circumstance where the doctor has, I will say, a fiduciary obligation to disclose and fails to disclose, whether those two equal fraud.
The other case that is cited in my brief for that proposition, Your Honor, is Robinson versus Shaw, a Kansas case, which is cited at page 27 of my brief, in which, in this case, it dealt with a foreign object as well, but as it happens, but it was a case where an object was left in the patient. The doctor took an X-ray and was aware of it, and then knowingly failed to tell the patient about that, and in fact said, "You're fine, nothing is wrong with you." And I believe it was 10 years elapsed before that was found out.
Let me ask you one more question. Is there anything in your record on summary judgment that suggests that the laceration, that the fact that a laceration occurred was negligent conduct on behalf of the doctor?
Yes, and that was in the expert letter of Dr. Charish, which was contained in both offers of proof that were presented at the tribunal, where Dr. Charish says that in the ordinary course of performing this procedure, that should not occur. If the procedure is performed according to the standard of care, the periocardicentesis procedure, that a laceration of the ventricle and subsequent blood loss should not occur. So yes, there was expert evidence on that issue.
Is there anything in the record that indicates that Dr. Chang either I'm actually asking you two questions, either actually knew or that he should have known that the baby's heart had been perforated?
He was present.
No, but
Didn't he see blood coming out? Was they aspirated?
Yeah.
They did.
Which was a definite sign that they had punctured something?
Well, there was blood. It was when they opened the baby's chest that they discovered.
Then they definitely saw it.
But Dr. Chang was present, participated in the procedure. Dr. Nelson, who was the fellow, apparently did the first attempt at the procedure when the complication first occurred, and then Dr. Chang took over at that point when there was a subsequent attempt to remove fluid. So both Dr. Nelson and Dr. Chang were there and present and knew exactly what had happened.
Thank you, Ms. Glinka.
Thank you.
Mr. Wakeman?
Chief Justice Marshall, members of the court, my name is George Wakeman. I represent all of the defendants in this matter. Let me begin by addressing a couple of the questions that were raised a moment ago. First of all, it is absolutely a matter of dispute that the family was denied the medical record in this case.
Well, we're here on summary judgment, right?
I'm sorry?
We're here on summary judgment.
Yes.
Correct. So it's in dispute.
It is in dispute,
Fine.
correct. The request must be made in writing. That's as a matter of Board of Registration and Medicine regulations, as well as the JCH, the Joint Commission of Hospitals. Hospitals cannot give out records without the request being made in writing, which, when that was done, the hospital provided the records to the family. The other issue that I think addresses both the Chief Justice's issues on a couple, or questions on a couple of things, and Judge Graney is that there really has been an address of the issue of fraudulent concealment in Massachusetts. That would be the Fowles versus Lingos case that is cited in our brief. And that says that to be fraudulent concealment on the part of a physician, the physician must either know or believe that there is a cause of action against him or her, and that failure to then provide that information would be considered fraudulent concealment. And your point exactly, Your Honor, about the fact that the word fraudulent is what is important.
Well, on a motion, would you agree that there's sufficient in the plaintiff's expert's affidavit, I take it, that this was negligent conduct?
The plaintiff's affidavit says that it was negligent conduct. And that, of course, is a matter of dispute. But what is important is that at no time, once the motion for summary judgment was filed, did the plaintiff file a supplemental affidavit from Dr. Cherish or any other physician, claiming that what occurred here was either an improper concealment, a fraudulent concealment.
Well, the test that you've just given me would make that very difficult. I mean, I'm looking at the Georgia Court of Appeals case that says if the doctor is negligent, there's almost if the doctor is negligent and doesn't disclose, it's almost, you can almost imply fraud. In other words, if you say the doctor must know that there's a cause of action.
That's what the Fowles decision said.
No, I understand, but in this context, there's a laceration. The doctor presumably knows that the laceration was not intended, shouldn't have happened. I mean, how is the plaintiff to establish that?
With all due respect, Your Honor, that's exactly the point, is that laceration of the heart is an absolute known complication and risk of the pericardiocentesis that was performed on the patient. So to have it occur would not in any way place a physician on notice that he or she had performed negligently in performing that procedure. It is a known complication and a known risk. The only thing that the plaintiff's expert says in this case is that, in my opinion, in this case, it was not a complication that arose in the absence of negligence.
Is it in the record that the laceration of the heart in this type of procedure is a known risk? Is that in the record?
I believe it is in the record, Your Honor, and in addition to which, Your Honor,
well, isn't that sort of important?
That it's a known risk?
Yes.
It's part of the record. It's also part of the discussion that was held with the patient, with the family before this procedure was done.
Is that in the record? Is that in the record that it was that? Because I recall the plaintiff making the claim that the family was not told of any risk in the operation.
Again, a point of contention or a point of dispute between the parties. The procedure really was done in an emergent fashion. So having
but this may be important to your to summary judgment, because if the plaintiff claims that the family was never told that this was a risk, and you're saying you don't think there's evidence in the record that laceration of the heart is a known risk of this type of procedure, then doesn't that go to the question of whether there was you could show there was no fraudulent concealment, clearly, if you could show that this was the evidence that this is a known risk, and you don't seem to have that.
There's no informed consent form in the papers, Your Honor, because of the circumstances under which the procedure was carried out. It was fairly emergent. There wasn't time to get the assigned form.
Could you address the death certificate? I mean, in your summary of facts, and I know it's disputed as to whether they were told, I mean, there seems to be an affidavit that the plaintiffs then told Ms. Langone that a short time after they were escorted, a nurse informed them of a complication during the procedure, specifically that he, Dr. Chang, had punctured the heart. I mean, I don't know when and if and how that arose, but just go to the death certificate.
Yes.
What does the death certificate indicate is the cause of death?
It's part of the record in this case, Your Honor, and it indicates that a number of things were the cause of death: failure to thrive, cardiac issues, which would include, it didn't list specifically, however, and that's undisputed, it did not list specifically the laceration to the heart.
Is there an affidavit or anything construed in the light most favorable to the plaintiff that could indicate that the laceration should have been listed as part of the cause of death?
There's nothing in the record that would indicate, including any statement from the plaintiff's expert by way of an affidavit in opposition to the motion for summary judgment, saying that that should have been included in the death certificate.
Was there a follow-up study done at the hospital as to concerning this child's death? I mean, was there a post hoc review?
I do not know I do not know specifically,
Has it-
although I will tell you that
There's an
most
autopsy.
deaths, I'm sorry?
There was an autopsy to
There was an autopsy.
examine the heart.
I think you're asking if there was a peer review.
Most
Well,
things like...
I was
the-
going to use the term peer review, but I was leaving you the opportunity to use it whatever other way.
I will tell you that there is no evidence in the record as to whether one was done or not. Typically, any death is
There is a
reviewed
peer-
at a mortality and morbidity conference, which is a peer-reviewed conference. If I may point out that there
And
it
have
is
those documents been requested?
No, they have not, Your Honor. But more importantly, the fact that a laceration occurred in this case is recorded in 4 different places in the record. The plaintiffs claim that there was fraudulent concealment, and yet, in the defendant's own note of the procedure in the chart, it talks about the fact that a laceration occurred. In the cardiac surgeon's note in the chart that talks about what he did in opening the child's chest, it documents that he found a laceration. The discharge summary lists the fact that there was a laceration of the heart, and finally, the autopsy lists that there was a laceration of the heart.
Is it the practice, is there any evidence in this record, one way or the other, concerning whether the discharge summary is given to a patient or parent of a patient?
If requested, the discharge summary would accompany the entire record, Your Honor. It is not
It's not
provided
a
as a
separate
matter
thing.
of routine
Okay.
to patients or to anyone else.
When
for
you
that
say
matter.
if requested, you mean in writing?
That's the regulations of the Commonwealth require that a record be requested in writing before a hospital or a physician can release it. But it is listed in those 4 places, Your Honor, very clearly.
So you
So there's no explanation for why the laceration of the heart was not included on the death certificate. We just don't know why.
There's no evidence in the record, Your Honor, as it exists, as to why it was not included in the chart, as to whether or not it was a medical decision, that it was a subsidiary issue that did not require being listed, that it was subsumed within what was listed. It's simply not a part of the chart or the record, Your Honor.
So you argue 2 things, essentially. First, that they can't get to first base, so to speak, on the fraudulent concealment statute because there is no, as a matter of law, there is no proof of fraud. And second, if they do get to that first base, then the proposed statute creates no exception for a fraudulent concealment. Those are 2 different arguments you make, or do you make the first one at all?
I'm not I think that the second one is the more specific.
That's the one you argue, so why should we bother with the first one if it's not raised?
The first one being, again?
That they don't make it to first base on even the applicability of the fraudulent concealment statute because there's no proof of fraud.
The plaintiffs have raised it, Your Honor, and so in response to that, I'm saying that there is no, under the case law of this Commonwealth, there is no proof of fraud here. There's neither, the court on the below, Judge Conley, was not presented with affidavits of fraud, and there's nothing from the record that would.
So is this a situation, if it comes to that, where we can uphold him on a ground not argued by the parties below?
I think you can uphold him on that. I think you can also uphold him on the fact that when Chapter 23160D was created, which is the statute of repose created in 1988 or 89 by addition, which was in direct response to the discovery rule articulated in Franklin versus Albert. In that situation, Your Honor, the legislature very carefully and very clearly considered and was aware of the fraud exception in Chapter 260, subsection 12, was aware of that. In enacting the medical malpractice, or the physician, if you will, statute of repose, the legislature specifically chose to enact and insert one exception.
Is there legislative history that actually shows they discussed, knew of, well, of course they knew of in a hypothetical sense, but discussed
This is for Hallfinger, wasn't it?
Pardon me?
Never mind.
The Hallfinger case,
Yeah,
and
just-
also, although it's not an appellate decision, Judge Fishman, interestingly enough, since he ruled on the prior case that you just heard, has recently issued a decision and went through, and it's attached in our brief, went through the legislative history quite exhaustively. And so it was clearly considered, again, referring to a comment that you made in the Chesterton case, Your Honor, limits mean limits. In this case, in no event means in no event. That is the language of both of the statute of reposes, whichever you look at. It says, in no event shall a cause of action, shall an action be filed later than 7 years, and with the exception of the foreign object. And the reason for that, the legislative history on that shows that the reason is because the legislature said that there's almost no conceivable instance where the standard of care could support leaving a foreign object behind in a patient. And so we don't have the same issues with memory and with staleness that we have in other cases.
Mr. Wakeman, I take it that you are saying that the fraudulent concealment, Section 12, doesn't even apply.
I think it does not apply, Your Honor, under the Sullivan versus Iantroska case. Iantroska case.
I take it that one reason why the legislature may, what you're saying is in this case, the hospital's medical records, which are available to a patient or the parents of a patient, including the autopsy report, which is available upon request, all documented the laceration to the heart.
Yes.
So that we really, in this case, don't even have to consider what we would do if there was evidence that there was laceration to the heart, but none of the hospital records made reference to them. In other words, where there is some reason to question if there was fraudulent concealment.
I think that is clearly an option that would be available to the court in deciding this case.
Can I just ask you one question, factual question? As I understand it, the mother or the parents, I'm not quite sure, returned to the hospital in April 2001 and had a discussion with Ms. Langone, the nurse in the patient's relations department. But that's April 2001. But as I understand it, there was a request, a written request, sometime in March of 2001.
I believe that's what the record in this case shows, Your Honor.
So in the April 2001 meeting, did the parents have the medical records?
I know that's reflected in the papers, Your Honor. I don't recall off the top of my head from the record below.
Can I just ask you something that I'm not sure I understand? Why do you say that Section 12 doesn't apply? Do you say Section 12 applies only to statute of limitations and not to statutes of repose?
As I read the Sullivan versus Iantroska case, Your Honor, in that case they said that the statute of repose bars the court from considering facts which would toll the statute of limitations, including minority, mental illness, or fraudulent concealment, citing to Chapter 260, subsection 12.
And again, that typically arises when there are mechanisms by which injured parties can obtain information of which the legislature might have thought a hidden object in your body. There would be no if the doctor doesn't know it's there, it's not going to be in a record. P.S. I left the swab inside the abdomen. That's not going to be in a medical record.
I would not suspect that would be in the record. Correct. If I may, in closing, Your Honor, I know that I'm over, but if I may have just a brief moment. What the plaintiffs have suggested here is that if the court does not grant the relief that they seek, that this will be an incentive to physicians to fraudulently conceal acts of negligence. First of all, I think that is a gross melodramatic statement. If a physician chose to do that, they would be running a huge risk, number one, that within the 7 years it would be discovered, and now not only would they have to defend a case on negligence, but also on fraudulent concealment. Secondly, there is still a remedy available in this case, and that is that even where the statute of repose bars a civil recovery, there's a much greater deterrent to any physician fraudulently concealing or altering records, and that is the Board of Registration in Medicine, which in the event that a physician knowingly conceals or alters records or information, that physician's license would be subject to revocation, which is a far greater, in my opinion, a far greater bar, if you will, or a far greater incentive not to do that than the threat of a lawsuit for damages covered in most cases by an insurance policy. Thank you, Your Honor.
Thank you, Mr. Wakeman.
All right. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable the Justices of the Supreme Judicial Court, now sitting in Boston within and for the Commonwealth. At present time, to give your attendance at this place tomorrow morning at 9 o'clock, to which time and place the sitting of this court is now adjourned. I'll say the Commonwealth of Massachusetts.